Good morning, everyone. My name is Robert Sickels. I'm a senior shareholder with the Dynamite law firm of Sommers Schwartz. I am here today with two of the star litigators from our litigation department, Ken Watkins. Say hello, Ken.
Good morning.
And John Malone. Say hello, John.
Good morning, everyone. John
And
Malone,
we're
nice to meet
here. We're here today, John and Ken, to talk about a jury verdict. The buzz on the street is that the two of you obtained a very sizable jury verdict, and we'd like to hear all about it. So, Ken, starting with you, can you tell us just a little bit about the case and how big was the verdict?
It was a sizable verdict, just under $5 million, wrongful death case in Oakland County in front of Judge Kwame Rowe.
Who were your clients?
The clients was the deceased, obviously, Mr. Charles Woodson, um, obviously not the famous Charles Woodson from University of Michigan, um, and then his lovely wife, Mrs. Woodson. Uh, they had a number of children as well, grandchildren, large
And who
family.
were the defendants?
The defendants was Beaumont Hospital chiefly, and their surgeon, Dr. Shannon, um, who was the proponent defendants who ate the verdict.
And tell us a little bit about the claim. What was the claim against these defendants?
Um, the deceased had to undergo a surgery for a condition called aortic stenosis. And it's often treated with open heart surgery. There's also an option to perform it percutaneously or transcatheter approach. The problem in this case was he was not given informed consent in order to make a informed decision as to which surgical approach, which was very significant.
And tell me about the defense position. How did they defend this claim?
Besides the usual, I didn't do it, nobody saw it, no one can prove it. They essentially suggested that they had provided all of the necessary consent communications and it provided a surgery that was indicated for this patient's aortic stenosis. They replaced the aortic valve and had a um, litany of complications in the postoperative period, including on the third operative day, he suffered a heart attack, um, largely due to providing a um, uh, beta blocker that wasn't not indicated at that time, and it caused the heart to significantly slow and go into an arrest. After that, it was a very um, challenged postoperative period for 30 days or so that he died on the 32nd day.
I understand this was a team effort. How did the two of you divide up the trial responsibilities?
I handled the opening and the closing. As far as breakdown in witnesses, we had John handled the economist. He handled the nurse practitioner um, expert, um, and I handled the experts regarding the surgery, the thoracic surgeons. Um, and it went quite well in that manner.
So, John, from your perspective, what were the keys to the winning the verdict?
I think the keys to winning the verdict were really an effective presentation to the jury, um, giving them the information they needed to make a good decision, but doing it in a way that really emphasized the importance of what they were being tasked with doing and the importance of the ultimate decision that Mr. Woodson had regarding the surgery that he needed, and why it is that he needed all the appropriate information to make an informed decision about that, and really emphasizing that aspect of it and putting it in front of a jury in the way that was very understandable and a way that they could make a really good determination on.
So this was essentially an informed consent case that your client did not receive adequate information regarding the procedure that the surgeon performed. Is that right?
That is
That's
correct.
correct.
In essence, it was an informed consent case. A lot of it comes down to the fact that our client was not provided with appropriate information regarding the options that he had and the different surgeries that may have been available to him. And as a result, he consented to a surgery which he would have been better off going a different path had he received that appropriate information.
Well, hospitals and doctors have armed themselves against these kinds of cases with mountains of paperwork that their patients are required to sign before a surgery is performed. How did you get over that in this case?
Well, I think there was a significant error in the defense, um, but it wasn't much that Mr. Tam could do with it because Dr. Shannon um, essentially um, erased a portion of the surgery that was available by testifying under oath that it had not been approved by the FDA. We knew in fact, and ultimately was proved to the jury that it was available the year prior to him offering the surgery. So there's not much that they could do to, um, I guess, get back up from that hit on the chin.
So I have another question
Yes,
that just crossed my mind as I'm listening to the two of you. The patient died, correct?
yes, correct.
So John, tell me how you were able to convince the jury that if the patient had been informed of this other surgical technique, he would have selected that technique as opposed to the surgical approach that the defendant did take in this matter.
A lot of that ultimately came from Mr. Woodson's wife, Brenda, who I think gave the jury some very important testimony in this case, both informing the jury of what kind of a man Charles Woodson was and informing them of the nature of the decision that Mr. Woodson was making in regards to the surgery he ultimately needed. The important piece in this being that nobody during the trial was denying the fact that Mr. Woodson ultimately needed some sort of surgical intervention to address the condition in his heart. However, everyone also acknowledged that this wasn't an emergency surgery that needed to be done. It wasn't even necessarily an emergent surgery. This was something that could wait weeks or months before it took place. And so when the jury was informed by Mrs. Woodson that had Mr. Woodson been provided with a significantly less risky alternative for having this procedure done in a catheter-based method as opposed to a fully open heart procedure, and testified that Mr. Woodson would have selected the significantly less risky approach for this elective surgery to treat his non-emergency heart condition. That testimony, I think, was very compelling to the jury, and I think the jury fully understood that any individual facing a choice between a much less risky procedure and a much riskier procedure, in an instance where it's not an emergency and they have the ability to make that choice, would choose the safer, less risky, far faster recovery option than the fully open heart surgery that Mr. Woodson was ultimately offered as his only option.
So tell me about jury selection. My concern in selecting a jury, if I were involved in this case, would be that oftentimes jurors put great faith, great trust in their physicians to make appropriate decisions for themselves, as opposed to managing their own care. Um, did this come out in jury selection? Was there a particular mindset of juror that you were trying to tap into?
Um, we were largely looking for jurors that were willing to take on the challenge to listen to what was provided to Mr. Woodson's family, and what literally had to be given to him with regard to how he make his choices, and they needed to be able to um, take that information and weigh it out objectively. And we looked for jurors that were willing to spend the time. Really, that's the key uh, in a case like this, because they want to be able to solve the problem. They don't want us to solve the problem and matter of fact tell them this is what the evidence, you have to go this way. No, we got to let them put the pieces together of the puzzle. And I think that was the successful route in this case. They um, weighed the options and what objective people would do with that kind of information under the circumstances. And it was an egregious error on the part of the defendant, particularly the way the evidence came out. I just don't think he fully appreciated that it was going to affect the juries in that manner.
So oftentimes these medical malpractice cases come down to a battle of the experts. Was that the case in this trial?
That was
John, you want
certainly
to?
absolutely that was certainly the case in this trial. There were very well qualified experts testifying on both sides. In a lot of ways, though, the really critical component of this in terms of testimony in an expert sense came from one of the defendants, Dr. Shannon himself, and his testimony relating to the availability of a catheter-based approach for Mr. Woodson's surgery at the time it was being offered. His testimony was ultimately that that procedure was not available to Mr. Woodson, not cleared by the FDA at the time. And conclusively, we established through the testimony of every other physician who testified with knowledge about whether or not that procedure was available, that the FDA had, in fact, cleared that procedure for Mr. Woodson, and it was available to him when his surgical options were offered to him. And so, in a sense, this wasn't a case where there were experts saying two different things about that critical issue. Everyone was actually in agreement that Dr. Shannon was flat wrong when he believed that the FDA had not cleared that procedure for Mr. Woodson at the time he was consented for surgery.
How long was the jury out?
For about 4 hours, was it, John?
Yes, that's about 4 hours.
And how many days of trial?
A 2-week trial with Wednesdays off.
How many witnesses?
Wow.
Just approximately.
Approximately 12 total, I believe.
So you have 2 weeks of trial, you have 12 witnesses, you have tons and tons of complicated medical information, and the jury just took 4 hours to decide in your favor. Is that right?
I think the time that the jury took in deliberating was really reflective of how attentive a jury we ultimately had. You're always searching for jurors who are going to pay close attention and understand the importance of the issues. And uh, throughout the trial, there was no question of the fact that we had an excellent jury who was very attentive. And I think ultimately the time in deliberation was reflective of the fact that they got it. There wasn't a lot of mystery to them.
Well, from listening to you today, my sense is that you must have had a jury who felt that patients are entitled to make decisions about their own health care, and that it's the physician's obligation to adequately inform them of their alternatives. Would you agree with that?
That's exactly right, and that's what the law requires in the state of Michigan.
Okay. I want to thank the two of you very much for joining me today. And with that, we'll say goodbye.
All right. Thanks a lot, Rob.